The prosecution ready to proceed with its closing argument?
Yes, Your Honor, we are ready.
Yes, we'll proceed, please.
Good morning, Your Honor. May it please the court. Your Honor, the prosecution will provide the burden of proof with the probability of evidence, and we also prove that all of the obtained evidence are legal and very important. Your Honor, in this regard, we will go over the four issues, establish the burden of proof, and we will prove why the prosecution has fulfilled all of these burdens. Your Honor, we will prove the evidence as follows. First, Senior Officer Strait had a reasonable suspicion that Arthur Parker was armed and dangerous to conduct the free search. Second, Betty was correctly and confidently identified the defendant, and thus the photo lineup identification of Arthur Parker was under a lawful process. Third, Officer Momo obtained the evidence lawfully, and since there was a reasonable belief that Arthur Parker has posed the risk, and that unclosed search is necessary to eliminate those risks. And fourth, Arthur Parker admissions to Senior Officer Strait and Officer Momo was obtained due to the lawful detention and interrogation. With the court permissions, we would now proceed to the issue number 1, which is about the free search.
Yes, thank you.
Your Honor, Senior Officer Strait has conducted free search since he had a reasonable belief that Arthur Parker was armed with a dangerous weapon, which to cause injury to the police and also the public. Your Honor, in Section 30, Paragraph 1 of the Southern Police Power and Responsibility Act, the police may search the person if the police has a reasonable belief that the person has posed the weapon or knife that would be caused the harmful to the public and also the person himself. Your Honor, in the Schedule 6 of the same law also provide that reasonable belief here, it refers to the logic and the rational thought which occur after the suspect person has made a action which create an actual belief to the other person that he or she is conducting a harmful action, a dangerous action to the public security. Your Honor, after Senior Officer Strait asked Arthur Parker to conduct the free search, Arthur Parker refused in an aggressive manner and also in a very nervous behavior towards Senior Officer Strait. Your Honor, Arthur Parker also began to get something out of his pocket at that time, as it was Arthur Parker was attempting to get the weapon from his pocket to against the public security or Officer Strait himself. Your Honor, therefore, the Senior Officer Strait is lawfully performed the free search at that time in order to prevent the harmful actions beforehand. Your Honor, the defense advocate may deny that Senior Officer Strait conducted the free search unlawfully due to the absence of the Arthur Parker consent and also the search warrant. Your Honor, may I refer the court to Section 29 and Section 58 of the Southern Police Power and Responsibility Act. The police may conduct the search without the search warrant if the officer has a reasonable belief that the suspect person has committed the crime or is likely to commit the crime.
Counsel, can you address what is the basis for a reasonable belief after Eltra says it's a stress ball, he reaches in and pulls out a stress ball. So what is the basis after that, at that point, to justify what is the basis, the evidentiary basis for a reasonable belief that she is holding a dangerous weapon?
Your Honor, regarding to your question, may I refer the court to the Schedule 6 of the Southern Police Power and Responsibility Act. The term reasonable belief here, it refers to a logic and rational thought which occur when the suspected person has conducted an action which is to make the other people believe that he or she is acting the suspicious act toward himself or the public security. Your Honor, may I refer the court to the fact that Arthur Parker, once he was arrived at the police checkpoint, he was nervous. And he avoided the eye contact with senior officer straight, and he was also respond in an aggressive manner.
Are you asking us to find that anyone who is stopped by a policeman and is very nervous about it, that is a reasonable basis to assume that they have a dangerous weapon? Is that what you're asking us to find?
We have more than that, Your Honor. So beside Mr. Ultra Manner, Your Honor, in that situation, senior officer Strait, based on his experience with the police officer about many years, and at that time he could assume that if the person did not pose any risk, did not hide any illegal weapons, he or she would agree with the police officer to conduct the search warrant. However, Arthur Parker refused to do so. And moreover, Your Honor...
So are you asking us to find that anybody who objects to being frisk searched, that is a reasonable basis to suspect that they have a dangerous weapon?
No, Your Honor. We do not ask the court, but at this time, we are trying to give the reasons to the court that as a reasonable person may believe that if the person did not hide any weapon, he or she must allow the police to conduct the free search, as he or she must also know that Southern is a country that is reported of the high crime. And at the same time, at the search point where it's conducted at the Pacific Avenue, it is the place where there is a record of the truck trade along at that avenue, Your Honor.
Okay, I get your point. You can move on. Thank you.
Thank you, Your Honor. So, Your Honor, in this, I would like to continue. So in this case, Arthur Parker is in a very close relationship with Maria, who was convicted for the drug dealing before. And addition, Your Honor, besides the Pacific Avenue was a high crime area, and also Arthur Parker refused to conduct research. In this case, Your Honor, it is reasonable to conduct the search without a search warrant or from the Arthur Parker. And Your Honor, after that, after conducting the free search, Senior Officer Strait found a scale of the measurement, which is believed that is used by the drug dealer to measure the scale of the drug, and also a large baggie that contains 750 grams of the cocaine, and also a large bag with a large amount of money as well. Your Honor, Senior Officer Strait in this case has a reasonable belief to conduct the research. Your Honor, the prosecution would now proceed to the issue number 2, which is about the photo lineup identification. Your Honor, the prosecution provides that the process of the photo lineup identification was conducted under the lawful process. In Section 617, Paragraph 1B of the procedure for evidence collection, the police officer may follow the photo identification, which contains at least the 12 people, and one of them is the suspected person. In Section 43, Your Honor, the witness may be asked to restate the number of the identified photograph, write the photograph number that on the photo, and also sign as well. Your Honor, on 1st March 2021, Barry was saw and also recorded the suspicious case to the police station. And at the police station, Senior Officer Strait has made a photo board of the 12 people of the similar appearance to Barry was. Your Honor, during that photo lineup identification, Barry was carefully viewed on that photo from one by one, recall her memory of the suspected person, and compare the personality of those 12 people as well. And after the careful consideration, Betty was identified the suspect person, she signed on the board, and also wrote the date on that photo as well. Therefore, Your Honor...
Madam Prosecutor, that's not exactly my memory of the facts. Bertie Walsh doesn't say she remembers identifying. In fact, Bertie Walsh say that she actually couldn't clearly remember the face of the person? I mean, wasn't that, and if she can't remember the face of the person, then isn't the face of the person the most important thing when we're identifying somebody?
Your Honor, we concerned with the court questions, even though did not identify clearly about the face of the person. Your Honor, in this regard, I would like refer to Betty was witness that she said that day she sat on the she was on the front porch of her home. So at that time she could see clearly, even though it is not the clear face of that person, but he or she must know about the hairstyle, about the skin tone of that person. And
how can we counsel? How can we accept as reliable an identification of somebody who has not seen the face of the person?
Your Honor, regarding to your question, 3 reasons. First, Your Honor, Betty Walsh has for the community crime watch for 2 years, and based on her experience in this community crime watch, she must have a skill of evaluating the suspicious act and
Counsel,
also understand.
Could you please, if you can, try to address exactly what I'm asking about, which is the witness did not see the face of this person and she cannot identify the face. So how can this court accept that as a reliable identification? If you can't see the face, how are we supposed to rely on this?
Your Honor, the prosecution was trying to give the reasons to your question about how we can rely on Betty Walsh's testimony.
Yeah, but the problem is, you see, and then we can move on. The problem is that the witness's familiarity in this program has got nothing to do with the fact that she didn't see this person's face. So what we're talking about here is what other indications of reliability regarding her identification of Eltra are there? Perhaps you could address that if possible, and then you can move on. Thank you.
Thank you, Your Honor, for your question. So in this regard, even though Betty Walsh did not clearly the face of the suspected person, at least Betty Walsh has identified this person about the face shape and also the hairstyle of that person, Your Honor. So that would be a reliable reasons that she used to judge on the photo identification. Thank you. Thank you, Your Honor. So therefore, Your Honor, the prosecution submit that Betty Walsh's testimony as under the lawful process.
Madam Prosecutor, I have one more question about this, because Bertie Walsh actually, when she was testifying, she said something in her testimony that I'm concerned with, and she said that, you know, she's part of this crime watch and she's concerned about drugs in the neighborhood. And then she said, after she made the identification, she said something along the lines that she was glad because she wants to help the police, that she wants to help the police. So isn't it possible that that's an improper motive of Bertie Walsh, that she wants to help the police, and that may be what creates the substantial risk of misidentification that she's doing, because she's a little unclear. And then I think through the cross-examination, we saw what Officer Strait did. He nodded, he agreed, he smiled, he did all these things. And then she says, and she wants to help the police. So can you help us with this? Do you agree it may be possible that Bertie Walsh just wants to help the police, and that's why she thinks that this was Eltra Parker? I understand we may not know, but do you at least admit that that could be a reasonable possibility, that she really wants to help the police?
No, Your Honor. In that, regarding to your questions, Your Honor, we would like to provide that as the South knew a high crime country regarding to the drug. So Miss Betty was the one, even though she was a retiree, but she want to help the country to join the community and also to watch the crime and report the crime to the police station. However, Barry Walsh has never known Altra Parker before, and at the same time, Miss Barry Walsh never had any conflict with Altra Parker. So that is not reasonable. Why Miss Barry Walsh have to told the police station and make a judge on to point out that Altra Parker was the suspected person, Your Honor.
Okay, thank you. Okay, you can continue. Thank you.
Yes, thank you, Your Honor. So, Your Honor, the prosecution also contend with the defense argument that Barry Walsh's decision was made under by senior officer Strait. Your Honor, may I refer the court to the section 43, paragraph 1 and paragraph 2 of the South Tunnels Police Power Responsibility Regulation. A police officer may ask the witness to view the photo board and also to carefully view on that photo board. Your Honor, during the photo identification, Barry was carefully recall her memory at that time about the person. And in the meantime, Officer Strait noticed that Barry Walsh has number 3, and that he was just to ensure whether Miss Barry Walsh has took the photo identification seriously. Your Honor, Barry Walsh recognized that Altra Parker was the person who committed this suspicious act in her community, and therefore her testimony is reliable and not under any influence from senior officer Strait. Your Honor, the prosecution would now proceed to issue number 2 for the unclosed search. The prosecution provides that Officer Momo has followed the law to conduct the unclosed search, and thus the evidence that obtained from the unclosed search is legal. Your Honor, in the Rule 15.10 of the South Tunnel Police Operation Procedure Manual, it provides that the police officer may require the person to remove the item of their clothing during the unclosed search. Moreover, in the Rule 15.20, 15.30, it allows the police officer to make description to immediately if the officer has a reasonable suspect that the person has posed the risk in the item of their clothes which to cause harm to himself or to the other person. Your Honor, during the free search, Altra Parker was and argumentative. He also refused not to cooperate with the police as well. Not only that, during that detention, Altra Parker has ignored officer question. He yelled and he cried from the holding cell and also tried to pull the zipper of his jacket and talking to himself and look straight to the officer Momo. Your Honor, in this case, in such a situation, Officer Momo must have a reasonable belief that Altra Parker was trying to get a weapon from his pocket, which to cause harm to other people in the holding cell. And therefore, Your Honor, Officer Momo has complied the law to unclose search immediately to eliminate the risk beforehand.
Counsel, is it your position that the precise threat that Altra posed was harm to others?
Yes, Your Honor.
Even though there's no evidence of that?
Your Honor, in the first place, because of Altra Parker's manner at that time, there's no requirement. Officer Momo did not know whether he posed any weapon inside him. So that's why he needs to conduct the free search immediately in order to eliminate the.
But Madam Prosecutor, if I can ask, I don't recall any testimony or evidence that there was anyone else in the cell with Altra Parker. Did Officer Momo say there was any? If you're saying that it was a risk to others, was there any evidence at all? I don't remember Officer Momo saying there was another person in the cell with Altra Parker. I understand there may have been, but my notes don't reflect that actually that evidence was gotten from Officer Momo. And this is your burden. This is your burden to establish. And if you've missed that fact, I think that may be a key fact.
Your Honor, in the holding cell, there should be the other detainee as well. And Officer Momo has made straight to the point of that. And Your Honor,
I understand, Madam Prosecutor, I understand there should be, but I don't think Officer Momo said there was.
Your Honor, if the court is not convinced with this, reasons. However, Officer Momo also concerned that Ultra Parker will use that weapon to harm himself. Do you satisfy with my question? Thank you, Your Honor.
You may proceed. You may proceed.
Your Honor, the prosecution also admit that Officer Momo did not invite Mr. Lanny Bloom, and also did not listen to Ultra Parker objections at that time. Your Honor, however, in the Rule 16.10 and 620, the police officer may not consider on the suspect or wait for the other police who experience with the LGBT to do so, because the law allowed the police to take an immediate discretion to conduct the unfree search to eliminate the risk. Your Honor, Ultra Parker, besides his aggressive and also pulling the zipper in the jacket, Your Honor, Officer Momo had made a reasonable belief that he must pose the risk, and in fact, Officer Momo did not have enough time to invite Lanny Bloom or listen to Ultra Parker objection at all. So in this case, Officer Momo has taken the Ultra Parker safety as a top priority in and Your Honor, therefore, Officer Momo has followed the law to conduct the enclosed search in this case. So now the prosecution would like to proceed to issue number 4, which is regarding an interrogation. Your Honor, may I refer the court to 203 of the detainment procedural rule. The police officer may detain the person in a reasonable time to investigate if the person is suspected of committing the crime. And moreover, in section 204 of the same law, the reasonable time here it's based on the situation that is necessary for the police officer to detain the suspect person for further investigation. Your Honor, during the free search, the officer straight has found a large bag that contained the white powder, which is record of the 750 cocaine, a black bag with large amount of money, and also a scale measurement as well. And later on, Ms. Berry-Walsh has confirmed that Ultra Parker was the suspect person who committed the crime at the community. And later on, Your Honor, after the enclosed search, Officer Momo found a note that is wrote by Alex Smith to call for the meeting at the night of the arrest. And Your Honor, Alex Smith is the person who is a well-known drug dealer in this afternoon. So Your Honor, based on all of these reasons, Officer Momo and Officer Strait has a reasonable belief that detaining Ultra Parker was very significant in order to find further investigation for this afternoon. Your Honor, it is also worth noting that Ultra Parker was detained under 8 hours and she was questioned under 4 hours as well. And therefore, her admit to the crime is in a well-capacity manner. Now, the prosecution consider on section 203, paragraph 1 and paragraph 2, Power and Responsibility Acts. A police officer may detain the person for reasonable time to investigate under the 8 hour and the maximum of the question is hours. However, Your Honor, the detention of Ultra Parker here was under 8 hours, and within this 8 hours, Ultra Parker was not questioned as she was given 2 hours to relax before the second interview. So, Your Honor, Ultra Parker had a reasonable time for reconsideration of his conduct as well. Therefore, Your Honor, after the second interrogation, Ultra Parker admit that she know about the existence of the white powder. And hence, Your Honor, Parker's testimony of the crime was true, and therefore the detention and interrogation of the Ultra Parker was under the lawful procedure. Your Honor, is there anything that I could assist the court in this case?
Yes, I've got a question, Madam Prosecutor, just in relation to the admission by Ultra Parker that she knew what the substance was. So as I recall the evidence, what the evidence was that she said yes in answer to a question, but she then retracted that answer very soon afterwards. Now, has the prosecution considered the reliability of that answer? So what I mean by that is, even though she said the word yes, is it a reliable admission to her state of knowledge about the presence of the drug?
Thank you, Your Honor. So it is the prosecution still provide that Ultra Parker admissions to the knowledge of that white powder was reliable enough, because, Your Honor, even though the defense advocate may deny that Ultra Parker was in a less capacity manner, she was stressed to answer yes. However, Your Honor, Your Honor, Officer Momo and Officer Street could not understand whether Ultra Parker was in a stressed manner, because Ultra Parker did not tell the police so. And moreover, Your Honor, Ultra Parker was very aggressive and argumentative at that time as well. Therefore, Officer Momo and Officer Street did not understand in a less capacity. And Your Honor, between the time of the first and the second interview, Ultra Parker was left to relax for 2 hours. These 2 hours, Ultra Parker must relax himself, and your identification of that drug is Your Honor, his testimony of the white powder is reliable enough.
But you see, as I understood the evidence, the evidence was that when Ultra Park was being questioned, initially she answered no to the question, but the police officers persisted with the question, and then eventually there was an answer of yes given. But I just have some concerns about the reliability of that answer in the circumstances of the persistent questioning.
Your Honor, since the court in this trial chamber, it refers to the evidence to provide the evidence in this court is to the balance of probability, which means that the evidence and the claim that provided by the prosecution, it only a greater than 50% chance that our claim is reliable and our claim is true. And Your Honor, based on our reasons at the moment that we provide relating to Ultra Parker manner, and also the inaction of the stress, and also the manner of Ultra, therefore, Your Honor, with of the relax, we consider we provide that Ultra Parker was in a well manner when she provided the answer yes to Officer Street.
So your position, if I may, and I think I understand this, your position is that it's not really proper for us to keep out this statement of yes, because you've satisfied your balance of probabilities. And your position is, of course, the defense is welcome to argue in the main trial these problems with it. But but at this point you've achieved your burden of letting this in, and this issue, in your opinion, should really be addressed in the main trial. Is that correct?
Sorry, Your Honor, could you clarify your question?
Yes. I think by you telling us about the balance of probabilities, what you're saying to us, and I think I understand, is that it's not proper for us to keep out this yes statement of Ultra Parker now. This could be let in at the main trial, and if the defense wants to argue that Ultra Parker constantly said no, and at one brief moment said yes and then took it back, the defense is well allowed to argue that, but that should be decided by the trier of fact in the main trial. It's not proper for us to keep it out now, because you've done your job and established the balance of probabilities. Is that correct?
Yes, Your Honor.
Okay.
So, Your Honor, may I proceed?
You may.
Your Honor, the motion of the evidence in this case must be denied, because all of the evidence obtained are lawfully and also very significant to assist the court to find out the major crime operation in the country. Therefore, Your Honor, the prosecution would request the court to of the evidence for further proceeding in the main trial. Thank you, and may it please the court.
Yes, thank you. Thank you very much. Now, is the defence ready to commence with their closing argument?
Yes, Your Honor. May I
Yes.
proceed?
Yes, thank you. Go ahead.
Your Honor, may it please the court. This case deals with the motion to exclude the evidence obtained unlawfully on the ground thereof. Your Honor, if a police officer does not respect the due process or procedure of law, how could other citizens believe in the law? This raises the question among general people that can government officials just do what they deem fit? In this case, Officer Strait and Officer Momo had broken the law and policy repeatedly by misusing their power. Therefore, Ms. Elcher Parker is entitled to question this court about the credibility and reliability of police officers of Zaltanu. On behalf of our client, the defense advocate is willing to stand up for this case and simultaneously help this court to determine that the evidence obtained as a result of frisk search, photo lineup, unclothed search, and interrogation violates the due process of Zaltanu's procedural law, which does not reflect justice at all. By now, the court is aware that on 1st March 2021, Officer Strait directed my client's car to a police traffic checkpoint. According to Section 29(2), even if the police officer is entitled to a search without a warrant, to avoid the doubt, he can search a person or anything with consent by the suspect or a search warrant. But senior officer neither took consent nor had a search warrant. Also, as per the Article 4 of the Constitution of Zaltanu, all persons have the right against reasonable or unlawful searches and seizures, but however, this right of Ms. Elcher Parker was violated by the officer. Your Honor, yes, I agree that the police officers are entitled to the discretionary power, but that does not imply that they can keep the law in their hand and disregard the laws of the country. As a defense lawyer of Ms. Elcher Parker, I am very respectful towards Officer Strait and the discretionary power he is entitled to. But isn't it the duty of the police officers to use the discretion by not violating the rights of others and by not disregarding the laws of the nation? Furthermore, Officer Strait searched for a weapon on Ms. Elcher's body without a warrant as per Section 30A as he is entitled to, but he just found a stress ball instead, which was partially visible and which Ms. Elcher clearly told him about. Officer Strait further searched and found an electronic scale without caring about my client's objection and refusal. The officer should have ended the frisk search, but she continued to perform this search without a warrant, consent, or any reasonable suspicion, and just found an electronic scale to confiscate. It seems obvious that Officer Strait was biased and prejudiced as he recognized Dane Carey from the previous arrest.
Madam Defense Advocate, if Officer Strait was so biased, then why didn't Officer Strait, the minute Elcher Parker got out of the car, why didn't Officer Strait just search Elcher Parker then? Isn't it the fact that Officer Strait says he didn't lay his hands on Elcher Parker until Elcher Parker actually reached for something? So if your position is he's so biased, why did he wait?
Your Honor, thank you for the question. As soon as he recognized Dane Carrier from the previous arrest, he says that he has a reasonable suspicion for that. After they were after they were stopped and were on the ground, Officer Strait asked for the identification and other official documents, which they clearly provided, but after C was reaching for stress ball, which was partially visible, and Miss Elcher also told him that it was a stress ball. Because
Madam Defense Advocate, again, you're saying that Officer Strait was biased, and this was really linked to Dane Carrier. Then why didn't he act before Elcher Parker reached for the stress ball? It seems that if he was so biased, he just could have done it at the beginning. But in fact, he didn't do it until Elcher Parker reached for something.
Yes,
so doesn't that negate the?
Yeah, that's because Officer Strait told that he would need to perform the frisk search. So she was nervous and she was reaching for a stress ball, but he has already set up the mind that he would conduct a frisk search on them because he was biased and prejudiced. And as per the prosecutor, Madam Prosecutor also said that Officer Strait recognized Dane Carrier from the previous arrest. So that leads to the possibility that the officer was biased and prejudiced.
Okay. It leads to the possibility, but it's not necessarily a convincing, because if that was the case, again, you could move on, but I'm stuck with the fact that Officer Strait didn't do this till Eltra Parker reached for something, but you can move on. Keep going.
Thank you, Your Honor. Here, I'd like to stress the fact that Schedule 6 of Jaltanu Police Powers and Responsibility Act defines reasonable belief as a belief that is arrived at through a process of logic or of a rational thought. A belief that is capricious or held as a result of suspicion or prejudice is not a reasonable belief. Therefore, Your Honor, as I already mentioned earlier, the belief of Officer Strait was established as a result of suspicion and prejudice after he saw Dane Carrier with Miss Eltra Parker. Here, I'd like to address the court that his reasonable belief did not qualify under Schedule 6 of Jaltanu Police Powers and Responsibility Act. And regarding the claim from the prosecution that my client was uncooperative, nervous, and became aggressive, the defense advocate would like to respond that it is legitimate for any person to ask for clarification as to the reason why their rights are being deprived, and if such deprivation is legitimate. And humans' feeling is like a chemical reaction due to the situation or circumstances people are in. So it is obvious that people find it aggressive or they might act nervous when their rights are violated, where the police officers conduct any performance without their consent, without a proper course of justice, and their requests are ignored. So this is why the law provides a clear line for justice administrators and police officers to follow by taking in the consideration of personal rights of the people by not affecting dignity, privacy, freedom, and emotional, physical, and psychological status of the people. Moving on to second issue, Your Honor, after receiving a call from Bertie Walls, Officer Strait conducted the photo identification. Now, turning the court's attention towards Bertie Walls, she clearly stated that she was unable to clearly identify the face of the person loading a package as she was reading a paper at that time. She just said that her focus was on the PDP logo and the blonde hair color. She did not see the face of the person. However, Officer Strait showed her a photo board containing 12 individuals, but only 2 of them had blonde hair.
Counsel, sorry if I can. What I recall from the testimony was not merely the blonde hair, but the hairstyle. Could you address that, please? Thank you.
It is the blonde hair color, Your Honor.
The witness said hairstyle.
During the cross-examination of Bertie Walls, while the defense advocate asked if she clearly told Officer Strait about the blonde hair, she agreed to the question. So, Your Honor, she agreed that she told Officer Strait about the blonde hair color of the person.
Yes, there was testimony about the hairstyle. So
it was hairstyle.
Yeah. And I understand that to be potentially different from the color. So if you can address that, good. If not, you can move on. It's okay.
But while the defense advocate asked during the cross-examination about the blonde hair color, the witness agreed. So I'd like to proceed with this because she agreed to the question that defense advocate asked.
Okay,
so then
you can go ahead. You go ahead.
Officer Strait showed him a photo board containing 12 individuals, but only 2 of them had blonde hair. This does not comply with the law in Section 670, which states that the photos of people who have similar appearance must be shown. Moreover, according to Section 43, Clause 3 a police officer is not allowed to raise any suggestive statement. But when Bertie Walsh was doing an identification, Officer Strait asked about the picture number 3 as he stopped there. Based on the answers of Bertie Walsh in the cross-examination, we can clearly say that there was an influence on Officer Strait on the identification that the Bertie Walsh made before and after the identification of my client. Bertie Walsh started to feel confident after Officer Strait suggested the identity of Elja Parker among 2 out of 12 people who had blonde hair. This is clarified because during the cross-examination of Bertie Walsh, she said that the Officer Strait seemed to satisfy with her answer by smiling, nodding, and saying, "That's what I thought." Therefore, the evidence obtained from the unlawful and duly suggestive photo identification should be excluded as it does not comply with the law as defined in Section 43 and shall be excluded according to Section 44 because this creates a substantial risk of misidentification, as he did not see the person's face, but he made an identification in the police station. Moving on to
why not let this in at the main trial and just let the defense argue these points? Why? I mean, while the prosecution has the balance of probabilities, the law says that this evidence should come in unless there's a substantial risk. So why not just let this come in and you can argue this in the main trial? If you could let me finish, please, without interrupting me.
Sorry.
Thank you. Because if you're so strong about this, what's the harm in us letting this in? In the interest of justice, what's the harm in us letting this in? You feel strong about your position and you argue this in the main trial. What's the harm?
Because Bertie Walsh clearly did not see the face. So how could an identification based on without seeing the face of the person can be used in main trial?
You could argue that in the main trial.
It questions the reliability of the evidence that is used by the prosecution.
And you could argue that in the main trial. Why are you asking us to keep this out? You're making very good points that you can argue in the main trial. So why should we keep this out?
Because it was a result of unlawful and suggestive photo identification, as by the Officer Strait. That's why it should be excluded, because the laws have been broken.
So your position is, even though you can argue this in the main trial, that you shouldn't be required to because you feel that there has been a violation of due process.
Yes, Your Honor.
Okay, thank you. You can move on.
Moving on to the third issue. After my client was brought to the cell, she said that she was stressed and she was playing with her zipper because of her stress. But she never put her hands in the pan. But Officer Mo made a false accusation by stating that she was putting her hands in the pan. If he noticed her playing with a zipper, the Officer Momo could have just checked the upper body part. Or otherwise, he could have handcuffed her and called Lenny Bloom, who was on duty at that very time. But perhaps he didn't. Similarly, Officer Momo was aware of the pre-arrest frisk search that was done by Officer Strait at the checkpoint, and the result of which found nothing harmful from her body. But as a matter of fact, Officer Momo ignored all the facts along the request of Miss Elja Parker and then proceeded on his own, disregarding the Rule 16.2. I would like to draw the court's attention towards the fact that Officer Momo said that he had no time to call Lenny Bloom because he was afraid that my client might harm herself or others in the room with a small zipper of her jacket, which she was playing because of her stress. But as per the testimony of Officer Strait, there is no clear evidence that there were other people in the cell as well. The defense advocate acknowledged the discretion of Officer Momo under Rule 15.30. He is entitled to search my client, but there was no reason to perform the search as per the clauses mentioned in the same law. And regarding the unclothed search, Officer Momo was aware that the frisk search had been already conducted and nothing harmful was found from her body. But he was in a hurry to perform the unclothed search without liaison officer who was there on duty, disregarding the laws of Saltino. Your Honor, this is the clear violation of law. Your Honor, my client has not been open about her sexuality, and she was in a phase where she was having a hard time accepting her sexuality, and she was very private about this. And one of the reasons she had stress issues was this, but Officer Momo, disregarding the physical and psychological.
Counsel, I don't remember any evidence that would substantiate what you just said, that the reason that she was stressed and had a stress ball was her sexuality or her gender issues. I just don't remember any evidence about that. Was there evidence of that?
Your Honor, while she was asked why she was uncomfortable about that, she clearly stated. Am I audible?
Not really. Maybe try it again.
We could hear you. We could hear you now. Please try again.
Okay.
So during the re-examination of Miss Eltra Parker, while the defense counsel asked her why she was uncomfortable about her sexuality and she had a hard time accepting her sexuality, that's why she was one of the reasons that she had stress issue was that. Am I audible?
Yeah, go ahead. Yep, go ahead. Proceed. Thank you.
Moving on to the fourth issue, Your Honor, my client Elcha was detained in Jaltanu police station for 8 hours. That is the maximum length of detainment. The police officer repeatedly kept on asking Miss Eltra the same question and continued to interrogate her. Your Honor, I'd like to draw court's attention towards the fact that Elcha was subjected to forceful, lengthy interrogation for more than 4 hours and a humiliating unclothed search in between, which is a clear violation of Section 203, paragraph 3, which clearly states that within 8 hours, the person may only be questioned for a maximum of 4 hours. Miss Parker was constantly asked the same question by the police officer, even though she was continuously refusing about the knowledge of the drugs found in her car trunk. By now, the court is aware that my client has had stress issues as well. According to Section 204, paragraph G, the suspect shall be provided enough time and breaks in between the interrogation, but my client wasn't given enough breaks in between. So as a result of stress and the fright from the previous chain of events, she was coerced into admission.
Madam Prosecutor, we heard from the prosecution witness she had 2 hours. 2 hours.
The defense witness, Miss Eltra Parker, did not accept this. She said that she had not been given enough breaks in between.
Okay, so we have a conflict in testimony. 2 hours by some witnesses. She says none. So again, shouldn't this now go to the main trial where this is argued at the main trial?
Yes, but yeah, she was not provided enough breaks because as a result of previous chain of events, she was exhausted and nervous. As Officer Momo in her testimony said that yes, she seemed tired and nervous, and she was continuously refusing the question. That also implies that she was having a hard time.
But you do agree that it's not. You're saying she didn't have enough breaks, but that's not.
Yes, Your Honor.
That's in conflict. You say she didn't. The prosecution says she did. So that's in conflict. There's not clear testimony one way or the other. These are not agreed upon facts. Is that correct?
Yes, Your Honor.
Okay, please move on.
So she was coerced into admission. Your Honor, I'd like to stress the fact that her admission was the result of series of overbearing conduct of police officers and was not done on her free will. It was a result of constant coercion and physical and psychological abuse, and which she took back instantly. Also, Your Honor, as per the police officers of Jaltanu Police Station, they are not clear about the time. Eltra was detained and interrogated, which clearly shows that they did not keep a record of time. As per the prosecution, it is only their verbal confirmation that my client was detained for less than 8 hours, but there's no evidence that shows that she was detained and interrogated within the designated time frame as per the law. But isn't it the duty of police officers to keep the record of the time she was detained and interrogated? Your Honor, if the senior officer disregard the rules and regulations, how could we expect other peoples to follow them? This raises a question on the reliability and credibility of the police officers of Jaltanu. Therefore, Your Honor, the defense requests that any evidence from the beginning of the checkpoint to the police station needs to be excluded because the police officers broke the law and policy of Jaltanu repeatedly, which substantially prejudiced my client. It is not necessary to argue here that what officers' intention was, but justice and access to fair trial is every individual's right, and my client is also entitled to it. Police discretion is necessary, but police officers still need to substantially follow the law and policy in order to realize the maximum expectation of justice. However, senior officer Strait and Mover violated it time and again. Your Honor, in conclusion, I would like to remind the court that in order to instill the principle of natural justice in the court and the country, the evidence obtained by invading the personal rights of Miss Eltra Parker and by neglect Eltra Parker neglecting the effect that might cause on her dignity, and evidence obtained as a result of non-compliance with the laws of Jaltanu needs to be excluded in this case. Ruling this evidence inadmissible will help maintain justice and minimize abuse of power happening in our country. Otherwise, it might create a negative impact in the country. Thank you, Your Honor.
Yes, thank you very much for that. So that concludes the hearing of the pre-trial argument. And as I understand it now, we'll close the hearing of the court, and